can be seated. Before we officially start the trial, I'm going to ask our jurors to introduce themselves, starting with juror number 1, Mr. West.
Hi, I'm Seth Wax. I was on the UCLA Law School mock trial team a couple years ago. Right now I'm a second-year associate, Sullivan Law.
Hi, Stephen Johnson, also a UCLA Law Trial Team alum. I practice in San Diego.
Hi, I'm Sydney Gaskins. I am a UCLA Trial Team alum, and I competed at this tournament when I was in college.
Hi, I'm Avery Hitchcock, UCLA Law Trial Team alum, and I am a litigation associate at Houston County.
You can copy his bio, but my name is Deeksha Bollier.
And juror number 6.
My name's Peter Jones. Yeah, I'm along the trial team here at UCLA.
And you're alive.
Yeah, which is bad news for, I guess, half the people.
Have you ever gotten a round of applause just by saying your name?
No, it's not so bad.
We're really excited about this panel. Everybody on their panel is either a law school national champion, a Top Gun, a winner of this very competition, or multiple of those things. We think you're going to have, though, some advocacy befitting the jurors in the box. So with that, we will open the case. We call the case of State of Peter Jones versus Dragon Studios, Inc. Can I get appearances, please, starting with the plaintiff?
Yes, Your Honor. Good afternoon. My name is Laniya, Davidson. I'm joined at council table with my co-counsel, Mr. Gabriel Rosella. We represent the estate of Peter Jones.
Good afternoon. Good afternoon.
Good afternoon, Your Honor. My name is Sam Farnsworth, and I'm here with Ethan Donovan. Good afternoon, Your Honor.
Good afternoon.
We represent Dragon Studios, represented at council table by Cole Doyle.
Good afternoon, Your Honor.
Good afternoon. All right, do we have anything to take up before opening statements? We'll start with the plaintiff.
Yes, Your Honor. We have a few housekeeping matters and one substantive motion.
Okay.
For housekeeping matters, can we invoke Rule 603 and 615 for the constructive swearing in and sequestration of all witnesses, foreign party representatives?
The 603 motion is granted. Regarding 615, do you have any exceptions for your part?
No, we do not.
Mr. Farnsworth?
We do, Your Honor. Cole Doyle will be here during trial.
Any objections?
No objections.
Okay, so that's granted with the exception of Ms. Doyle.
Then we'd like to ask your preferences for movement about the well, approaching opposing counsel, the witness, jury box, bench.
So I want you to make use of the space. The only exception is if you're going to approach the jury or give something to the jury, ask permission, but otherwise make free use of the court.
All right, Your Honor, that's all we have for housekeeping matters. Should we move on to the motion?
Let's hear if there's any housekeeping from Mr. Farnsworth.
Yes, Your Honor. Per the rules of this jurisdiction, we have to announce what verdict form we're using for this trial. We're using Form C.
And remind the court that means which defenses are available to the defense in this case.
We're denying negligence and pursuing a claim of comparative fault.
Okay, so the jury will not be hearing anything about assumption of risk when it comes to the verdict.
Correct.
Okay. Anything else?
No, Your Honor.
Okay, Ms. Davidson, you had a motion.
Yes, Your Honor. We'd like to motion to exclude Exhibit 36 under Rule 404, improper character evidence.
Can you remind the court what Exhibit 36 is and explain the basis of your motion, please?
Yes, Your Honor. Exhibit 36 is an interview that Mr. Jones had done before his death. It describes the actions and stunts that he had done previously in the past. The title of it is that that he had risks and he chose to accept them, and that he throws caution to the wind. Your Honor, we'd like to exclude that under Rule 404, that it's trying to show that he had risky behavior in the past, and that is likely to do it on the day in question.
This is the Gaskins article, is that right?
This is the Gaskins article.
Mr. Farnsworth?
Yes, Your Honor. If we use this document during trial, we're only going to be using it for 404B evidence to prove intent. That when he heard the plan, he intended to do something different to make a death-defying stunt. And under that exception, it's admissible.
Can you explain a little more how that argument worked?
Yes, Your Honor. We believe in this case that when Ms. Doyle pitched a stunt plan to Mr. Jones, he agreed. But we're going to use this article to show that when he agreed, he actually intended to do something different.
Response?
Yes, Your Honor. This article was written well before Ms. Doig ever made the changes to the stunt plan. They can't be using this for 404B to show intent. They're just trying to show that because he would take risks in the past, that therefore he was willing to take a risk on the day in question. That's improper character evidence.
Is this about the same movie?
Yes, Your Honor. It actually happens the very same month that the stunt happened.
Does the plaintiff agree this is about the same movie?
Your Honor, we agree that it's about the same movie, but we have it on a good faith basis that the plan that was in place during this time for the movie is not the plan that happened on June 21st. That plan changed on June 20th that he could not have agreed to or could have been talking about at this point in time.
Okay, I'm confused because as I understand from the party's papers, we're here about the stunt that happened during All Law 7. This refers to All Law 6.
Yes, Your Honor, but this interview takes place while All Law 7 was being filmed, and we
Okay.
believe that the references made apply in this case as well, given the timeliness of the article, that it happens on June 1st, and the stunt that went wrong happened only 20 days later.
Response?
Yes, Your Honor, considering it's about his past stunts that he's done, and it's about him taking risks, and that he could not have agreed to the stunt plan that was in place for this case. This is just being used to show that because he was risky before, he was willing to be risky again. That's improper character evidence.
All right, here's what we're gonna do. I think based on what I've heard so far, this feels like improper character evidence, and so my ruling right now is to exclude it. However, if you believe that something happens during trial that makes it clear that this is 404B evidence that's permissible, we can have a conversation outside the presence of the jury, and we'll reconsider that issue.
Yes, Your Honor.
Okay, so for now, it's excluded. Anything else?
Nothing else.
Nothing else from us?
Plaintiff, you can open.
Thank you. May it please the court. They push the limits. He paid with his life. It's June 20, 2023. Movie star Peter Jones is standing at the top of a mountain. He's about to attempt the greatest movie stunt ever captured on film. He rides a motorcycle down the side of a mountain, off a cliff, goes into a free fall, deploys his parachute, and then safely on the ground. But the producer, she's not satisfied. No, she wants Mr. Jones to do something more daring, to have the shot go longer, to deploy his parachute later. She tells him to do it again. So, Mr. Jones goes back up to the top of a mountain. The producer, she watches from the control room. Her one job, to hold the walkie-talkie and give the signal for him to deploy his parachute. She's staring at the monitor, waiting for her perfect shot. Mr. Jones goes down the mountain, off the cliff. He's in free fall. And she waits. And waits. And waits, watching as he's falling, waiting for her shot. That call never comes. She was silent. They pushed the limits. He paid with his life. That's why we're here today. That's why Mr. Jones's family is suing the defendant, Dragon Studios. Members of the jury, we're suing for negligence. And that means we have a burden. A burden to prove, more likely than not, that Dragon Studios failed to exercise ordinary care. Specifically, that they failed to act, and they should have. We're going to meet our burden today by proving 3 simple facts. Fact number 1. They pushed the limits of their stunt. Fact number 2. They pushed past those limits. Fact number 3. Their failure to act caused Mr. Jones's death. Let's walk through those one by one, starting with the first, that they pushed the limits of the stunt. You're going to hear today from Mr. Jones's agent, Eli Goupion. She's going to tell you that what Mr. Jones agreed to was a safe skydiving stunt. But we expect you'll also hear from the Dragon's producer, Miss Doyle. She'll tell you that she wanted more. She wanted a longer shot. She wanted Mr. Jones to deploy his parachute later. She pushed for more time. Which brings us to the second fact. You're going to hear that they pushed past those limits. The day of the shot, the producer was supposed to be giving the signal for Mr. Jones to deploy his parachute, and you're going to learn that that signal, it never came. Because she pushed past what they had already agreed to, extending the shot even further and further. Which brings us to our third fact. That it was that failure to act, failure to call for his parachute that caused his death. After that call was never made, you're going to learn it is undisputed. Mr. Jones died because he plummeted to the ground at over 100 miles per hour. Now, in a moment, we expect a defense will get up here and they will try and say that was Mr. Jones's own fault that he died. Because he liked to do stunts and take risks, but members of the jury, there was no way Mr. Jones could have known that that call was never going to come. That's why, at the end of today's trial, I'll come before you again, and I'll ask that you find Dragon Studios liable for negligence. Because they pushed the limits. He paid with his life. Thank you.
Thank you, counsel. Mr. Farnsworth, would you like to open?
Yes, Your Honor. May I proceed?
You may.
He took a risk for the perfect take. It's June 21st, 2023. Movie star Peter Jones is getting ready for a big stunt. He straps on his parachute. He hops into his motorcycle and he puts in his earpiece. He's nervous. He's about to drive off a mountain. Now, he's done this stunt before, but this time's different. It's his last take, and he needs it to be perfect. He hits the throttle, rushes down the ramp, and flies 2,700 feet up in the air. He feels the air hit his face, and adrenaline shoots through his body as he begins to fall. After 9 seconds pass, contrary to what the plaintiff just told you, he hears a call. Pull, pull, he hears. Mr. Jones isn't ready. He wants the perfect take, and the longer he falls, the better the shot will be. He thinks he has a few more seconds he can wait. A few more seconds he doesn't actually have. So when the second call comes and Mr. Jones hears, deploy, 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 this time he rips open his parachute, but it's too late. Mr. Jones hits the ground and dies. He took a risk for the perfect take. Everybody in this courtroom agrees that what happened to Peter Jones was a tragedy. It absolutely was. But today you're going to learn his death wasn't the fault of Miss Doig or of Dragon Studios. No, you're going to hear they took steps to train Mr. Jones and to ensure his safety on set. But what you're going to learn is that on the day of the crash, when Mr. Jones hears the instruction to pull his parachute, he doesn't. You'll see that's why he died. I want to be clear about the law. The plaintiff has the first burden of proof in this case. They have to prove by a preponderance of the evidence or show you it's more likely than not that Dragon Studios was negligent, or in other words, that they failed to exercise an ordinary care. And they also have to prove that failure caused Mr. Jones' death. They're not going to be able to make their proof. But even if they do, we have a burden of our own to do. We've elected to pursue something called an affirmative defense, something called comparative fault. That means we're going to show you it's more likely than not that Mr. Jones failed to exercise ordinary care for himself. And that's why he died. 3 facts are going to show you why we prevail. First, they exercised care. Second, they sent the signal. And third, Peter Jones kept going. Let's walk through what each of those mean. First, that they exercised care. The evidence will show that Dragon Studios invested a lot into Mr. Jones' safety. They didn't just have him practice to jump once or twice. No, you're going to hear they had him practice jumping from motorcycles and skydiving over 1,000 times each. You're going to learn they built sets in California to have him practice that jump, that they exercised ordinary care and healing. That brings us to fact 2, that they sent the signal. We're going to call producer Cole Doig to the witness stand. She was actually in the control room the day that Mr. Jones died. She's going to tell you exactly what happened. That after Mr. Jones spent 9 seconds falling, she told him to deploy his parachute. That she said, pull, pull, pull. You're going to hear Mr. Jones did. And that brings us to fact number 3. Peter Jones kept going. Today you're going to learn that Peter Jones loved his do anything for the audience attitude. You're going to hear that he was told the night before this stunt, the longer the fall, the better the day. You're going to hear he had a reason to push beyond the limits of what he was told to do. You're going to see that's why he passed away. Throughout this trial, I want you to focus on the risks Dragon Studios protected Mr. Jones from, and the risks that they couldn't control. If you do, I'm confident that you'll see Dragon Studios didn't cause Mr. Jones' death. And that's why we'll ask you to find the defendant, not Laniya. Because he took a risk for the perfect. Thank you.
Thank you. Thanks.
We'd like to call our first witness, who we call Eli Goudion. May I proceed?
Yes.
Good afternoon. Could you please introduce yourself to the members of the jury?
Hello, my name is Eli Goudion.
What do you do for a living?
I'm a talent agent.
What were you doing in June of 2023?
I was working on a stunt with Peter Jones. He was my client. We were working on this movie, All Lost. Maybe you've heard of it. It was the 7th installment.
Ma'am, you mentioned that you were Mr. Jones's agent. I just want to be clear. If the plaintiff wins this lawsuit, are you going to see any of the money from it?
No, I wouldn't.
Then let's talk about the movies that Mr. Jones was working on.
Okay.
What exactly was he filming in June of 2023?
We were working on All Lost 7. It was the 7th movie in the All Lost franchise.
Were there any stunts involved?
Yeah, there were a couple of stunts, but we were working on the biggest stunt in the movie. He would get on a motorcycle, drive off a ramp, release the bike, and free fall until he would pull his parachute and land safely on the ground.
And do you know who the producer of that stunt was?
That was Miss Doyle. She owns the production company, Dragon Studios.
Well, let's talk about Miss Doig's approach to producing. Oh, did she have a role in that stunt on June 2023?
Yeah, so Miss Doyle was in the control room. It was her job to give a signal to Peter through this.
Objection, Your Honor. Lack of foundation. Maybe her.
What did the witness say that you think lacks foundation?
What Miss Doig's job was in the control room. We don't know how the witness knows that.
Counsel?
Yes, Your Honor, she's testified that she was his agent, was working with him during those movies, and has testified to what the stunt was. I asked her, did she know what Miss Doig's role was supposed to be, and she answered she does.
Yes, Your Honor. We still don't know how this witness knows what the plan was supposed to actually be inside the control room. We've just heard this witness was his agent. That's not enough foundation for this kind of opinion to be on the record.
Was the witness there?
Yes, Your Honor. She was there on June 21st.
Okay, I'm gonna allow it for now. If you think it goes beyond what this witness knows, you can renew your objection.
Yes, Your Honor.
What was Miss Doig's role in that stunt?
So she was in the control room. It was her job to give Peter a signal to pull his parachute through this earbud that he was wearing.
Were you there for the stunt that Peter was filming?
I was in the control room with Miss Doig.
When were you supposed to film that stunt?
Well, the filming was supposed to happen on June 20th, but we continued filming until the next day, the 21st.
Well, let's talk about that June 20th filming. What happened on that day for the stunt?
Well, on June 20th, we ran the stunt maybe 6 times. Every single time, we would wait 4 seconds, Miss Doig gave the signal, and we would land safely.
You mentioned that you filmed it another time. Was that originally in the plan to film a second day?
No, it wasn't.
How did that second day of filming get added?
Well, Miss Doig asked if we could do another take. She said that she needed some more footage of him in the air, a longer time between when he jumped off the ramp and pulled his parachute.
So just to be clear, who proposed doing that extra take?
Miss Doig did.
Then let's talk about what happened when Mr. Jones filmed that second take. Your Honor, may I approach with Exhibit 2, which has already been pre-admitted as a video, and also show it to the jury?
Yes. And both parties can move at any point to see exhibits shown by the other.
That was going to be my next question.
Right, ma'am, do you recognize what this footage is?
This looks like the footage from the 7th stunt that we did, the one on the 21st.
Can we play until 10 seconds? Ma'am, at this point, how many seconds has it been since Mr. Jones has left the ramp?
About 4 seconds.
Did Ms. Doig give the signal to deploy the parachute at this point in time?
No, she didn't.
Can we play until 9 seconds after? Right, we are 9 seconds after Mr. Jones has left the ramp. Did Ms. Doig give the signal at this point?
No, she didn't say anything.
What were you doing at that time?
I was yelling at her. I was telling her, tell him to deploy.
Can we continue to play the video? At any point in time, did Ms. Doig give the signal for Mr. Jones to open his parachute?
No. No, she never said anything.
Retrieving Exhibit 2. And let's talk about what happened after. Did you go down to the crash site?
We did. Miss Doig and I got into a helicopter and we went down to see if Peter was okay.
Was he?
No. No, he opened the parachute too late. He was falling too fast. No.
Did either you or Miss Doig say anything?
I was yelling at her. I was asking her questions. I asked her, how could you do this? Why didn't you give the signal at 9 seconds?
Objection, Your Honor, hearsay.
Response?
Yes, Your Honor, this is not hearsay because there's no truth in the matter asserted. These are questions and we expect to elicit a response from Miss Doig.
Yes, Your Honor, there absolutely is truth in the matter asserted. They're using this to show that Ms. Doig didn't send the signal at 9 seconds. The statement, why didn't you send the signal at 9 seconds, has truth value.
May I respond to that?
Yep.
Your Honor, even if you find that there is truth value in that question, this falls under an exception under Rule 803.2. It's an excited utterance. That is a statement that was made during a stressful event at the time while still under the stress of that event, Mr. Jones' death.
Okay. The court finds that there is truth value to the statement. However, that truth value is already on the record in the form of this witness's observation. She said that Ms. Doig didn't give the signal. I think this is being offered to show the effect that it had on the listener. Are we going to hear a response from Ms. Doig?
Yes, Your Honor.
Okay. If you can connect that, then the objection's overruled. Go ahead.
Yes, Your Honor.
And when you asked how could you do this, how did Ms. Doig respond?
She said she just wanted a longer take.
Objection, Your Honor, under Rule 403. Can it be heard?
Yes?
I believe opposing counsel just asked, what did she say after you asked, how could you do this? That's a different question than what the previous objection argument was about. What she said after being asked, why didn't you stop the signal at 9 seconds? And to put these questions out of order to suggest her response to one question was actually a response to another substantially misleads the jury.
Ms. Davidson?
Your Honor, my question was, after you asked how could you do this, how did she respond to that? She gave the response that she gave. It's not substantially more prejudicial than probative or more misleading. That was the response she gave to that question.
Okay. I take your point. I guess from the court's perspective, the witness is answering the question about what your client said. If you think that something was left out, then you can impeach the witness on cross-examination or make that point.
Yes, Your Honor.
So I'm going to allow it, and you can take it up. Go ahead.
So after you asked how could you do this, how did Ms. Doig respond?
She said that she wanted a longer take.
Thank you. Your Honor, I have no further questions.
Your Honor, at this time, I'm going to re-raise my hearsay objection. We didn't hear any sort of response from Ms. Doig to the question, so it can't be being used for the effect on the listener.
Your Honor, one, not only were those questions asked back to back, like I said before, this would fall under an exception either way, under an excited utterance, asking why didn't you give the signal while under the stress of watching Ms. Doig not give that signal and Mr. Jones fall to the ground. That would be an excited utterance.
Okay. So here's what we're going to do. I'll confess that I don't have a transcript of everything that's said, so why don't you re-ask the question, we can pause the clock, you can re-ask the question to make sure I understand what the question was and what the answer was, and then you can re-raise the objection so I can make a ruling.
Yes, Your Honor.
Okay.
Would you like me to re-ask?
I want to know what this witness said to Ms. Doig and what Ms. Doig said in response.
What did you say to Ms. Doig when you were at the crash site?
I asked her, how could you do this?
Did you say anything else to her?
Then I asked her why she didn't give the signal at 9 seconds.
Did you ask these questions back to back, one after the other?
I think that I asked, how could you do this? And that's when she said that she wanted the longer take. And I asked her why she didn't wait 9 seconds. She didn't respond.
And were both of these asked while you're standing at the crash site?
Yes.
Okay. Do you have an objection?
Yes, Your Honor, we still do. Ms. Doyle's silence does not constitute effect on the listener in this case. There's no effect on the listener being offered.
Okay. So we've got 2 questions, one of which got an answer and one of which we heard silence. Is that my understanding right?
Correct.
Yes, Your Honor.
Okay. So the only objection is the one that drew silence.
Yes.
What's your hearsay response?
Your Honor, my hearsay response is that is an excited utterance. Your Honor, she was standing there at the crash site where Mr. Jones had just died. After watching Ms. Doig fail to give that signal, she yells out, "Why didn't you give that signal?" That's an excited utterance.
Okay. Response?
Yes, Your Honor. Between the times that this witness saw Mr. Jones crash and when she made this statement, she and Ms. Doig actually flew a helicopter from a mountain down to the crash site. That's more than enough time for any sort of exciting condition to be affected that to have passed.
May I respond to that, Your Honor?
Yes.
Your Honor, that is not enough time for the exciting condition to have passed because they went down to the crash site of where his body was. She was still under the stress of that incident.
Have we heard that? Have we heard anything about the witness's condition at the time of the statement?
Your Honor, we heard that she had went down to where...
Sorry, have we heard anything about the witness's emotional state at the time that she made the allegedly excited utterance?
Your Honor, we heard about her emotional state in the control room and that she went down immediately afterwards.
Okay. I'm not convinced that this is excited utterance based on the foundation we've heard. I do think, though, that Ms. Doig's silence afterwards is relevant, and so what was said before that, I think, is fair game. I'm going to allow it, and the jury will take it for what it's worth.
Yes, Your Honor.
Okay. We're back on the clock. Do you have additional questions for this witness?
No further questions.
Okay. You can cross.
Yes, Your Honor. Before I begin, may I approach the witness with exhibits 10, 12, 16, and 18? They're all already in evidence.
Yes.
Good afternoon, ma'am.
Good afternoon.
I want to begin by talking about the Care Dragon Studios exercise. The stunt that we just watched involved a jump off a ramp, correct?
Yes, that's true.
We can agree, Dragon Studios built a practice ramp in California for Mr. Jones, true?
Yes, they did.
Mr. Jones practiced jumping off a motorcycle using this ramp, correct?
Yes.
He didn't just do it once, did he?
No, he didn't.
Objection, Your Honor, under improper character evidence. Rule 404 may be heard.
Yes.
Your Honor, what's at contention today is whether or not Ms. Doig gave the signal for Mr. Jones to deploy his parachute. What happened previously while they were practicing is just going to try and show the character trait for Dragon Studios being safe in order to show that they were safe on the day in question. Your Honor, that's improper character evidence.
Yes, Your Honor. We're using this to show that Dragon Studios met the burden they had to exercise ordinary care in government. If opposing counsel wants to stipulate everything before that moment wasn't negligent, we're okay with that, but until they do, this is still relevant.
Are you offering that stipulation?
Yes.
Would the plaintiff accept the stipulation that everything before, right, we should be clear, everything before what?
Everything before the 5 seconds on June 21st from the beginning of the stunt to the end of the stunt was not negligent.
So, for example, what the jury saw in Exhibit 2?
Yes.
Okay. So the defense is suggesting that we stipulate that everything prior to what the jury saw in Exhibit 2 has no, the defendant exhibited no negligence. Would the plaintiff accept that stipulation?
Yes, we would.
Okay. So then, do you still have any purpose in using those exhibits?
No, Your Honor, we're okay with that.
Okay. Go ahead.
Let's talk about what we saw in Exhibit 2. Ma'am, on June 20th, 2023, Mr. Jones fell for about 4 seconds each time before deploying his parachute, right?
Yes, that's true. After 4 seconds, Ms. Doig would give the signal.
June 21st was a little different though, wasn't it?
Yes, that's true.
The night before, Mr. Jones had a conversation with Ms. Doig, right?
Yeah, he said that he wanted to wait, or that she wanted to wait 9 seconds instead.
She also said that interviewers might want to know how long Mr. Jones was willing to fall, correct?
Yeah.
Now, in your time working with Mr. Jones, you know that he insists on doing stunts no one else will do, true?
Yeah, Peter always does his own stunts.
He's told you he loves his do anything for the audience attitude, right?
Objection, Your Honor, to improper character evidence.
Your Honor, we're not using this for improper character evidence. We're using this to show motive, that he had a motive to break from the threshold on the day in question.
May I respond to that, Your Honor?
In just a moment, can you explain a little more how can you explain a little more how this goes to the decedent's motive?
Yes, Your Honor. We're showing that the decedent had a reason to go past the limit and ignore the call he heard.
What was the reason?
That he loves his do anything for the audience attitude, that he could brag about in interviews, and that Ms. Doig would say on the interviews, which I just asked this witness about, that he was willing to do anything for the audience.
Your Honor, this is going to show Mr. Jones's attitude, that he was willing to go further. Your Honor, that's being used for improper character evidence, not motive.
So I want to make sure I understand what the testimony being offered is that this is his general attitude, or that he had bragged about this in the past?
That he had bragged about it. He had told this witness he loves his do anything for the audience attitude.
Okay. So here's what we're going to do. I'm going to permit testimony that the decedent had bragged about it, because that might be motive to want to do it in this case, to keep that reputation. But we won't hear evidence, and I don't think it's being offered, but we won't hear evidence that he actually had such an attitude.
Yes, Your Honor.
Okay, go ahead.
Ma'am, it's true that he told you he loved his do anything for the audience attitude, yes?
Yes.
Let's talk about what that might have meant on June 21st. Because that day, ma'am, he fell for 16 seconds before deploying his parachute, true?
Yeah.
Now, on direct examination, you claimed that Ms. Doig never sent a signal, true?
She never gave the signal.
Well, let's talk about why you might be saying that. Because, ma'am, isn't it true that you and Mr. Jones, you were friends, weren't you?
Of course, we worked together for maybe 10 years.
You weren't just friends, you were close friends, true?
Absolutely.
You weren't just close friends, he was one of your biggest clients, right?
Yeah, I think we worked on over 10 movies together.
He was your first client, true?
Yes.
And now, it's hard not to notice how many people are watching this trial, isn't it?
Objection, Your Honor, to argumentative.
It's cross-examination, Your Honor.
Well, I do like argumentative questions, so I'm going to allow it. Ms. Davidson, you can do some too. Go ahead.
Ma'am, you see how many eyes are on you, right?
Yeah, there's a lot of people in here.
You see those cameras watching you right now, right?
Objection, Your Honor, to a lack of foundation.
I'm going to allow it. Go ahead.
Ma'am, you see those cameras watching you right now?
Yeah.
Ma'am, you know Mr. Jones' family, don't you?
Yeah, I do.
You know each of them by name, true?
Yes,
You know where they live, right?
absolutely.
Now, you don't know if his family members are watching testify, do you?
I'm not sure. I'm sure they are.
You do know. They're the ones who stand to gain if Dragon Studios is found liable. Isn't that right?
I know that they're bringing the lawsuit, yes.
Thank you. No further questions.
No redirect, Your Honor. Just ask that Ms. Young be able to step down.
Your excuse. Thank you very much.
Your Honor, the plaintiff calls Cole Doig to the stand. Your Honor, under Rule 611, may we treat Ms. Doig as hostile?
Any objections?
Yes, Your Honor, we haven't seen how this witness's attitude on the stand, and until we do, that's premature.
May I respond?
Yes.
Your Honor, she's their party representative. We should be able to treat her as hostile. She has everything on the line here.
Yeah, I think under Rule 611, as an adverse witness, you're entitled to use leading questions regardless of the witness's demeanor. So you're allowed to lead the witness on your direct.
Yes, Your Honor.
And I've instructed the jury to make sure, for the purpose of this examination, when you're evaluating, treat this as the plaintiff's cross-examination and the defense's direct examination. Ms. Davidson, you can proceed once the witness is on the stand. We'll have Ms. Doig take the stand.
Good afternoon, Ms. Doig.
Good afternoon.
Let's start off by talking about why Mr. Jones was doing that fatal stunt in the first place.
Sure.
And on June 20th, you and Mr. Jones had done the stunt, correct?
That's right. We wanted to run it a few times and get some film for it.
Right, but on June 20th, you were running a plan which had him deploy his parachute after 4 seconds.
That's right. That's what we had discussed in the stunt plan before that day.
And you shot that film 6 times.
That's right. 6 times we got it on screen.
But after you shot that 6 times, you went back and you watched it, right?
That's right. I watched the footage that night and I noticed that it looked a little short.
Right, you didn't think it was good enough.
I just thought it looked shorter and we wanted it longer for the movie.
You say we, ma'am, you wanted it longer for the movie, right?
Well, I did, but we all felt some pressure to, make the movie good.
So that's yes, you wanted it longer for the movie.
That's right, I did too.
So Ms. Doig, you came up with an idea of how to change the stuff.
That's right. You see, that night I talked to Mr. Jones and his agent, and I said that we could make the scene longer.
Right, ma'am, you came up with the idea to push from 4 seconds to 10 seconds, right?
That's right.
You wanted to push from 4 seconds to 10 seconds because you felt that shot was too short.
That's right, and that's why I asked Mr. Jones and his agent.
You wanted to push from 4 seconds to 10 seconds because you thought audiences wouldn't be impressed.
That's right. I mean, there's a pretty high bar for those stunts that Mr. Jones had come up with.
And you wanted to push from 4 seconds to 10 seconds because you felt pressure from the audience, right?
Yeah, that's right. I mean, I think we all did.
Now, let's talk about whether or not you gave that signal. You were here when Ms. Goudion testified, correct?
I was, yes.
You were here when she said you never gave that signal, right?
I was, and I had no idea why she would say that. I made that signal. She was there in the room with me.
Right, Ms. Goudion, she was standing right next to you then.
Absolutely. She was there in the control room. It was her and me.
You said you have no idea why she would say that you didn't give the signal.
I have no idea.
Right, that's because you know that Ms. Goudion is a trustworthy person. You believe that.
That's what I thought, yeah.
In fact, you believe she is one of the most honest people in this town.
Absolutely. I have no idea why she said that.
Well, let's talk about why you may be saying that you did give the signal. Ma'am, you own Dragon Studios, right?
That's right, man. But the reason I'm saying that is because it's true. It's because I made that signal.
Ma'am,
I
that's a
promise.
yes. You own Dragon Studios.
That's right.
You were the producer for those movies.
That's right.
You were in charge of all of the filming.
That's right.
And ma'am, you were in charge of holding that walkie-talkie.
That's right. It was my job to make the signal at 9 seconds. That's what I did.
Let's talk about what happened after you claim you made that signal. Because you went down to the crash site, right? You and Ms. Goudion, you were standing there.
That's right.
And we were watching Mr. Jones's body on the ground.
That's right.
And while you were doing that, she said something to you, correct?
Yeah. Yeah, she asked me, how could you do this? And I told her the truth. I said that we needed a longer scene, and that's why he was up there in the first place.
That's right. She asked you, how could you do this? And you answered, I wanted a longer shot.
And of course, that was the conversation we had the night before, that we needed a longer scene, so Peter was going to do it again. We were going to do it for the 9 seconds.
Then she also asked you, why didn't you give the signal at 9 seconds, right?
That's right, that's what she asked.
You didn't say, you're wrong.
No, I mean, she was there. She heard me say it.
You didn't say, I did give the signal, what are you talking about?
No, I don't think I said anything.
Right, you didn't say anything to that.
No.
The only statements you said at that crash site were, I wanted a longer shot. I thought we had more time.
That's right, I did. That's why I let the stunt happen in the first place.
Thank you. No further questions.
Any question, Liz?
Yes.
Good afternoon, ma'am.
Good afternoon.
I want to take a step back for a second. Ma'am, could you just take a second to introduce yourself to the jury?
Of course. Hi, my name is Cole Dorida. I'm a producer.
Where do you work?
I work at Dragon Studios.
And ma'am, were you involved in the production of All Lost 7?
I was. I was working as a producer, as a writer.
Okay. We've heard testimony today about an actor named Peter Jones. Ma'am, could you tell us what your relationship was like with him?
I know what producers look like in the movies, but we spent years on these movies with this whole franchise, and Peter and I, we worked together for 11 years. He was one of my closest friends.
What stunts was Mr. Jones planning on doing for the movie?
Well, you know, Peter called us up and he said that this time he wanted to get on a motorcycle and ride off the side of the mountain in Norway and then let go. That was the stunt.
And did you have a role in that stunt?
I did, yes. You see, when he was going off the mountain, we were going to be in the control room and we were going to tell him when to pull the parachute so that he would know when to do that.
Did you take that role seriously?
Of course. It was in the stunt plan and everything.
Let's talk about what happened on June 20th and 21st.
Sure.
Ma'am, how did the stunt go on June 20th?
I mean, it went fine. We ran that stunt 6 times, and every time I held a pole, it pulled, and made it back down to safety.
Did you need another take after those 6?
Well, yeah. We were looking at the footage, and it was short still, and so I asked Mr. Jones and his agent if we could do it again, one more time.
Why?
Well, we thought that for the movie, if the scene was a little longer, that would be a little bit.
Objection, Your Honor, to speculation. Maybe heard.
As to which part of the answer?
She's answered, we thought that. Your Honor, I'd just like to limit it to what this witness actually believes, not what other people believe.
Response?
I can lay my foundation to make it appropriate, Your Honor.
Okay. So, why don't you lay the foundation, and then we'll revisit the objection.
Yes, Your Honor.
Okay.
Ma'am, what did you talk about with the defendant, or pardon me, Mr. Jones and his agent?
Well, we talked about the stunt, and we talked about the movie. And when I asked it if we could do it again, if we could do it longer, well, Mr. Jones agreed.
Okay. And let's talk about what happened June 21st.
Do we have any objection?
Your Honor, no objections to that.
Okay, go ahead.
Ma'am, how did the stunt go that day?
Well, I mean, at first it started off fine. You know, he got on his bike, he started going off the mountain.
I want to walk through exactly what happened from your perspective on the day of the stunt.
Sure.
Your Honor, I'm approaching the witness with a laptop that has Exhibit 2 on it. It's the same exhibit as earlier. Thank you, Mr. Donovan. Here you go, ma'am. You see that okay?
Yes, sir.
Okay. Ma'am, what timestamp is that video at right now?
It's at, it's at 7 seconds right now.
And what do you see Mr. Jones doing?
Well, that's Mr. Jones, that's Peter. He just started going off the ramp on the motorcycle. He just left.
Okay, from this moment onwards, what was your job supposed to be?
Well, my job was supposed to, I was supposed to wait the 9 seconds, and then after that, I was supposed to tell him to pull his parachute. That was my job.
Okay, what I want to do is have Mr. Donovan play the video, and then you tell us when you told him to pull the parachute. Would you be okay with that?
Of course.
Okay. Mr. Donovan, could you go ahead?
There. That's when I yelled, pull, pull. And then I waited for him to pull.
Let the record reflect the video has been paused at 16 seconds.
Record will still reflect if counsel agrees. I don't have a timestamp. Is that?
I promise, it's 16.
Your Honor, I
Ma'am, at this exact moment, what did you tell Mr. Jones to do?
I told him to pull. I was yelling, I yelled twice. I said, pull, pull, and I waited for him to pull.
After you told him to pull, what did Mr. Jones do?
I mean, nothing. He didn't pull. He didn't pull, so I, I panicked and I said it again. I said, deploy, deploy, deploy.
And in between when you said pull, and deploy, was there any time?
Yeah, I mean, I paused. I waited for him to pull.
Okay. Now that you've heard your perspective, let's see Mr. Jones. Mr. Donovan, could you play it out? And do you know what happened after that video cuts out?
Yeah, there were 3 more seconds of it, but eventually he pulled in it, and it was, it was too late. He was too low. And he died. He died. He hit the bottom of the mountain and he died.
And what did you do after that video cut out?
Well, Peter's agent and I, we took a helicopter down to the bottom of the mountain, just the crew said, the crew said he died, but, we need to go see what happened, and, I wanted to know what was wrong. We just thought, we had to test the earpiece.
Ma'am, how sure are you that you told Mr. Jones to deploy his parachute at 9 seconds?
I'm 100% sure. I was looking at the clock, it was 9 seconds.
Thank you. No further questions.
Redirect.
Go ahead.
Stoic, I want to make one thing very clear. You would lie to an actor to get a better scene, wouldn't you?
Objection, Your Honor. That's outside the scope of my cross-examination.
Response?
Your Honor, this isn't outside the scope. This goes to her credibility. That's always probative, regardless of whether he crossed on. And this is about stunts and what she would say.
Overruled.
Yes, Your Honor.
I've told actors before that, we were gonna shoot the scene at 3 seconds, and we actually had to do the stunt at 1 second count off, to make it more real. I wouldn't make a stunt more dangerous.
So that's a yes. You would lie to an actor to get a better scene. Yes?
Sure, a white lie like that, sure.
No further questions.
Recross, Your Honor.
Go ahead.
Ms. Stoy, did you ever lie to Mr. Jones about when you plan on pulling the signal or setting the signal?
No. I told him the night before I'd give him the signal of 9 seconds, and that's what I did.
Why wouldn't you lie?
It was his life on the line, that was my job, was to tell him when I'd pull it, and then I'd actually tell him to do that.
Thank you, ma'am. No further questions.
Nothing further from the plaintiff, we rest.
Ms. Stoy, you can step down. Thank you very much.
Your Honor, the defense doesn't have a case in chief. We're ready to move to closing argument.
Okay. It is 3:42 on my clock. We're going to take a recess. You can prepare for closing argument. Let the jurors stretch their legs. We're going to start back at 3:50 sharp.
Well, it'll be a long.
You can be seated. All right, do we have a full jury back? Thank you. All right, is the plan prepared for closing argument?
Yes, Your Honor.
Comments?
Yes, Your Honor.
Great. And you've gotten timing information from your timekeepers?
Yes,
I
Your Honor.
imagine you both have more than enough time. You can proceed.
May it please the court? A white lie like that? 1 second to 3 seconds? Yeah, I do. Those are the words of their producer. Those are the words that she said on that stand. Would she lie to an actor to get a better scene? She would. As members of the jury, she was willing to do anything to get that better scene. She was willing to push for anything to get that longer shot. And you heard today she kept pushing and pushing and pushing everyone to get Mr. Jones back up on that mountain. She pushed the limits. He paid with his life. Members of the jury, that's why we're here today. That moment in time when Mr. Jones is going off the side of that mountain and she's got a walkie-talkie in her hand, that moment is why we're here today. That's why we're suing for negligence. Because in that moment, they had a duty to give that signal, to do what was safe, to do what they had planned. And you've seen today, it is more likely than not that they did not give that signal. And we showed you why. With 3 simple facts. Fact number 1, the defendant pushed the limits of that stunt. Fact number 2, they pushed past those limits. Fact number 3, it was their failure to act that caused Mr. Jones's death. So let's take those one by one, starting with the first one. The defendant, they pushed the limits of that stunt. Members of the jury, to begin with, that stunt, it was wild, wasn't it? Going off the side of a mountain on a motorcycle, going into free fall and parachuting. It was a big stunt. But they ensured that it was going to be safe. Mr. Jones, his agent, they all agreed to what they were going to do. Ms. Doyle would stay in that control room. She would have a walkie-talkie. She would let him know when to deploy that parachute. 4 seconds, it's safe. But then you heard she needed to push him. push it. Not just 4 seconds, 10 seconds we were going to make this shot. 10 seconds. And why? Because she felt it wasn't impressive enough. She felt the shot wasn't long enough, that audiences would not be impressed by Mr. Jones going off the side of a mountain. Now today, the defense has tried to say it was Mr. Jones who wanted to take those risks. That was the attitude he had, that he liked to brag, that he wanted to take those risks himself, but it wasn't Mr. Jones who suggested taking a 7th take. Mr. Jones, though, he went 6 times off that ring. 6 times he did it. And he was good with 6. It was the defendant who wanted the 7th take. It was the defendant who wanted to push the limits of what he could do, but they still had a plan. We're going to push it from 4 to 10, but at 10 seconds, I'm giving you that signal. Which brings us to our second fact. They pushed well past those limits. Members of the jury, Ms. Gouguian took the stand today and told you she was in that control room. She was watching that screen right with Ms. Doig. She was watching the time tick down, watching as Mr. Jones fell. And Ms. Doig did nothing. Nothing. Ms. Gouguian is in there yelling at her, deploy, deploy, tell her to pull it. Silence. Ms. Doig was too busy focusing on the screen, focusing to see if they got enough footage for their movie. Mr. Jones had to pull that parachute on his own. But you heard today that was way too late. Now, the defense today, they've tried to say, no, Ms. Doig, she was in there. She definitely gave that signal. Now, there were only 2 people in that room, Ms. Doig and Ms. Gouguian. And I expect the defense will get up here and they'll try and turn this into a she said, she said. How would we know which one is right? And members of the jury, you get to weigh everything you've heard today. So let's weigh the credibility of the 2 witnesses you heard. Ms. Gouguian, according to the defendant herself, one of the most trustworthy people, one of the most honest people in this town. Whereas the defendant, she's willing to lie. Willing to lie to actors. Willing to lie so that she can get good scenes. Members of the jury, would you weigh who's more honest, who's more truthful? The defendant's not winning out. Well, it's not just that you have to weigh their credibility. You have to weigh everything else that happened. Because you learned today, right afterwards, they went down to the crash site. And Ms. Gouguian, she asked her, why didn't you give the signal at 9 seconds? Members of the jury, ask yourselves, why would she ever ask that question? If Ms. Doig had given the signal at 9 seconds. That was a statement that both of them agreed to. And she asked, how could you do this? Ms. Doig, I wanted a longer shot. Members of the jury, that's not all. You also get to weigh what each of them has at stake. Doig, she's a producer. She's the producer. This is her production studio. She has everything at stake. Ms. Gouguian, she's an agent, but you heard today, she gets nothing from this. She has no stake in this. Mr. Jones is already gone. She has no reason to be lying about what occurred in that room. So when you have to figure out what occurred in the control room, you can figure out it's more likely than not that Ms. Doig did not give that signal. And that brings us to the third fact. It was that failure to act that caused Mr. Jones's death. Members of the jury, it is not hard to believe that when you are up in the air, 2,000 feet in the air, you are going off the side of a mountain into free fall, and no one is giving you a signal, when you hit the ground, you're not going to survive. No one is going to dispute that because that's exactly what happened. Mr. Jones, without that signal, he hit the ground and he died. The defense is going to try and tell you that it was Mr. Jones who tried to push it further, that suddenly he wanted to die that day after doing the take 6 times, always deploying his parachute one time. He just decided, oh, no, this time I really want to fall fast to the ground. This time I want to hit it. Members of the jury, he wasn't thinking that. The reason he hit the ground, the reason he's not here today, is because the defendant never gave that signal. Members of the jury, this is the verdict form. Let's walk through it together. The first question asked whether or not we met our burden to prove that Dragon Studios was negligent. You've heard today that in that control room, Ms. Deutsch, she never gave that signal. She let Mr. Jones plummet to his death, so you can check yes. The second question is for the defense. Did they prove that Mr. Jones was negligent, and that's what caused his death? Members of the jury, there is absolutely no evidence today that Mr. Jones wanted to pull that cord later. There is absolutely no evidence that it was Mr. Jones who made that decision. So where it says that, you can check no. And then finally, it asks you to allocate the responsibility between Dragon Studios and Mr. Jones. Whatever you write here has to add up to 100, but whatever it is, you have to make Dragon Studios' number higher than it is for Mr. Jones. Because when it came down to that moment, when it came down to whether or not she gave that signal, she decided to hold off, to push and push and push the limits until she pushed too far. She pushed the limits. He paid with his life. That's why we ask that you find Dragon Studios liable for negligence. Thank you.
Closing argument from the defense. Proceed. Is all this case comes down to. Because we agree with opposing counsel that this entire case boils down to one question: what really happened in those 5 seconds? Did Miss Doig actually send the signal, or did she not? I'm going to give you 3 good reasons you know she sent that signal. Before I do, I want to talk about the law. Because opposing counsel is right, in a few moments you will go back to deliberate. And you will see this verdict. The first question on this form is, did the plaintiff prove the defendant's negligence caused Mr. Jones' death? Now, their allegation today is that Miss Doig never sent a signal. So it was their job to prove it's more likely than not that she never actually sent it. It wasn't our job to prove that she did. So now let's get to those 3 reasons I just told you about. How do we actually know that Miss Doig sent the signal? The first reason is the plaintiff's witness has a reason to lie. Opposing counsel said, let's weigh their credibility. And you know what? I agree. Let's do that. Because you heard that Miss Gouillon, she was Peter Jones' agent. She was close with his family. Family who stands to gain money from this trial. Do you really think Miss Gouillon would want to sit right here, take the witness stand and say, you know what, yeah, it was my client who ignored an instruction from a stunt woman? No, absolutely not. When you're weighing their credibility, you still have to remember that witness's bias. And they say, you know what, Miss Doig, she's the defendant in this case, she stands to lose money. So let's call that first reason a wash. Let's go to reason number 2. The defendant's story matches up with the video evidence. Let me be specific. When you go back to deliberate, you're going to have exhibit 2. Miss Doig took the witness stand and told you that she sent that signal at 16 seconds. That's exactly what she said. And she also told you what she said to Mr. Jones. That she said, pull, pull, took a pause, and then said, deploy, deploy, deploy. So what I want to do now is start the video from this moment, and I'm going to give the signal that Miss Doig gave that day. And let's see together if the timing lines up. Go ahead, Mr. Donovan. Pull, pull, pause, deploy, deploy, deploy. That's the timing that matches the evidence. That's the story that makes sense. But the best reason you have to know that Miss Doig actually sent that signal is what she did right after the crash. Now, this moment in trial happened quickly, but it's important you remember it when you deliver. At the end of my examination of Miss Doig, I asked her what she did after Peter Jones died. She said after she checked out, the very first thing she did was check to see if his earpiece worked. Why would she ever do that if she hadn't said anything? Use your common sense. You check if your earphone's working when you think sound is supposed to be coming out of it, but it's not. Miss Doig expected sound to be coming out of that earphone. That's why she wanted to check if it worked. You can trust her actions over the plaintiff's witness's words. They haven't met their burden. But even if you think they do, we have raised an affirmative defense of comparative liability. And when you go back to deliberate, I want you to think about the percentages of responsibility each side had. Mr. Jones had a responsibility to himself to follow the instructions he was given. We've shown you through the evidence, both circumstantial and direct, that he received that signal. And when you're assigning numbers here, I also want you to think about the fact that the plaintiff and us have agreed. Dragon Studios exercised ordinary care for all of their time working with Peter Jones outside of those 5 seconds, no matter which way you find what happened. But the fact is, folks, if you're still wondering what happened in those 5 seconds, what's more likely than not, then the plaintiff hasn't proven their case. That's when I'm going to ask you to do something difficult. Because I understand how hard this case is. You might have known Peter Jones. You might have seen him in the movies or on the television screen. To hear that he died while working on a stunt, that's tragic. Absolutely. I'm going to ask you to separate the tragedy from the liability. And find Dragon Studios not liable. Thank you.
May I proceed?
Amen.
Members of the jury, what this comes down to is who wanted to push the limits. The defense today, they've said it was Mr. Jones. We've proven today that it wasn't. That it was that production company. Because they've tried to say today that Mr. Jones, well, he just didn't pull that cord. That Miss Doig, she gave that signal. Members of the jury, today you've seen it in that video that they showed you, you watched. That signal, it didn't come. Mr. Jones was falling far too fast. He crashed because he didn't get a signal in his ear. Mr. Farnsworth, he stood up here and he tried to recreate what happened. Pull, 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 deploy, 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 then the parachute. Members of the jury, that's not what they agreed to. So why would Mr. Jones change? It wasn't him watching the footage. He didn't know what it looked like. No, it was Miss Doig. She pushed the limits because she wanted that better shot. And it was that reason that killed him. Find Dragon Studios liable for negligence. Thank you.
Thank you, counsel. I'm going to submit this matter to the jury in just a moment. But first, let's give them a round of applause. Can we have our Ms. Gogian stand up, please? Volpert from Penn, and our Cole Doig. That's Audrey Vanderslice from Harvard. All right, we will turn it over to the judges. We'll give them a moment to submit the ballots, and then we'll do some very brief feedback. All the ballots. I'm going to ask everybody to give some feedback. And normally we give constructive feedback during the tournament to help everybody get better. It's the final round. So I'm going to ask each of you your favorite moment from each of our two attorneys from the final round. I'll start with Seth. Favorite moment from plaintiff and favorite moment from the defense. And I guess before we do that, why don't you introduce yourselves, let them know where you're from.
Hello everyone, I'm Laniya Davidson, I'm from Maryland.
Hi, I'm Sam Farnsworth. I'm from Chicago.
Your cross-examination, direct examination, I suppose, of the defendant was incredible. I thought that was really, really good. And your closing argument, particularly when you timed your words with the actual exhibit, I thought was one of the better uses of an exhibit that I've seen. So, really, really good job, both of you. This was amazing to watch.
The plaintiff's opening statement story at the very beginning and the defense, the pause you took on your cross-examination between the answer that ended with she died, or he died, and the next question you asked.
I thought your cross-examination was amazing. It was the type where you just hold your breath while you're cross-examining. It was dynamite. And I loved the ping pong after that cross-examination to your direct. I thought you had the best direct demeanor. And also when you came up and closing in that low tone. Amazing.
A lot of the same, but I love your cross-examination. I thought it was really invigorating, and it was just very, very powerful. And not to just completely copy Cindy, but I thought the way that you were able to really flip the script around and really turn a sympathetic character back from this evil corporate defense that we've just heard about was really, really effective.
I'm going to give, I feel like people are doing nice, performative things, and they're taking all the good ones. So I'm going to say on the plaintiff's side, I really liked how you, stuck with your 404 objections, and, Justin was going for it. So I like that you stuck with it and tried to catch it every time. And then I really liked your cross of spooking right here. I thought that you found, you're really theatrical, and I really enjoyed that in your opening and your cross.
For the plaintiff, yeah, I thought your opening statement was phenomenal. I mean, I was really, really impressed by it. And not just because I was a character. For the defense, I thought your cross-examination of your client was really impressive. I think it's one of the hardest things to do, to sort of take a step back and introduce the witness and have it feel natural. I thought you did it masterfully.
I thought you two were exceptional. And I'll say this was a really fun round for me and a special one because I've gotten to know both of you really well. I'm glad I didn't have a ballot in the round. Laniya, I've gotten to know you a lot better over the last years. You've made the decision amazingly to come to this law school. We're so excited to have you. And I've known Sam since you were a teenager at Gladiator and getting to know you and your family and then getting to work with you a little bit. It's so cool to see how good you've gotten, and I'm really proud of both of you. My favorite moments from the trial, and there were a lot, I loved in your closing when you made the credibility argument. Because it did come down to who's telling the truth. It seems like there's no way that they could both be telling the truth. And I think you made a really compelling argument that one person was just more credible. And I really liked the way you grabbed onto the hearsay objection, saying they didn't connect the dots, they didn't tie it up. I thought you drew blood there. Even though it came in, I thought your listening was really impressive, and I thought that was very effective. This was a very good round, but we have a sword to pick up. So, stop me if you've heard this before. So we had 6 ballots, but one of our judges conflicted, so we knew that Sydney's ballot would not count before the round. So we had 5 ballots that would count. This came down to 1 ballot. And as I think we say every year, it came down to 1 check mark on 1 ballot. This year's national champion of trial by combat is Sam Farnsworth.